welcome to week 3 of Media Law at Wilmington College. We're going to talk about 3 topics today, and the first one that's going to be on this video is going to be obscenity. And remember, from our other 2 classes, we talked about the fact that the Constitution and other documents guarantee us certain freedoms, particularly the freedom of speech, freedom of the press, etc., that are found in the First Amendment. But we also, as we've discussed in class, need to keep in mind that not all speech is protected under the First Amendment. And we talked about some of the types of unprotected speech. Some examples are printing information that may affect the outcome of a trial. For example, we talked about gag orders, obscenity, which we're going to talk about today, and fighting words are some examples of things that aren't protected under the First Amendment. As we indicated in class, for example, you can't scream fire in a crowded movie theater with the thought of inciting panic. Obviously, if there's a fire and you want to warn people, that's one thing, but if you're just doing it to incite panic, you don't have the right to just verbally, express anything that you want. And obviously, obscenity is one of those items. The Supreme Court, as we talked about earlier, has consistently held that prior restraints, remember we talked about prior restraint in class 2, where there's some move by the court or by some party to hold back speech before it's actually spoken or written or printed or whatever. And the Supreme Court's consistently held that prior restraints on free expression are less acceptable than punishment for the questioned material after its publication or after you say it. So in other words, prior restraint is looked on disfavorably or not with favor, and it's kind of one of these punishment versus forgiveness things. I mean, it's better to express yourself freely and and suffer the consequences later than to be censored, as it were, through prior restraint. And we're going to talk about obscenity because obscenity is one of those things that doesn't obviously give. There's not license for obscene statements, etc., or obscene publication. So the time, manner, and place and methods of determining the degree of speech that can be restricted are things we need to look at. Well, again, as an example, in colleges, First Amendment rights are not vitiated or eliminated or terminated or reduced in a school setting. There's the Hosty case, which is in the book. Colleges and universities, subsidized publications, are subject to censorship. So school officials have a limited right to remove books from libraries if they determine that there's obscene material, that kind of thing. They have a very limited right in that respect, but they can regulate the acquisition of books or the use of books in the school curriculum. So they can pick books that don't violate their standards or whatever. Obscenity, and we're going to talk about what obscenity is in a little while, and we talked about it in class. Obscenity is not given constitutional protections, but indecent speech is. And remember George Carlin and the 7 words you can't say on TV. But it can be regulated. We've talked about the FCC, and the FCC can regulate speech that goes over the airwaves. The Supreme Court has ruled obscenity cannot be sent through the mail or through interstate commerce. It's also held that obscenity that is already within your home for private viewing is constitutionally protected, but child pornography is obviously not one of those constitutionally protected things that you can view in your home. Courts held that, many times they've held that child pornography statutes are overbroad and could inhibit free expression, but there is a constitutional consideration that courts have to go through when they look at child pornography, and we kind of touched on this in class the other day with the discussion about the compelling state interest test, where there's a law, the law is assumed valid by the court, and the defendant has to come in and prove that they that this law is violating their rights in some respect, and then the court has to show, or the prosecutor, whoever, has to show the court that there's an overriding reason why the regulation should occur. And obviously, protecting kids from pornography is an important aspect of that. There's there's several cases that are in the text and that you can look at. The first one is Neer versus Minnesota, and this was an after publication punishment. And again, we talked about the fact that it's courts hold generally that it's better to publish someone after the fact than to try to prior restrain them. In that case, basically held that it was that punishment after the fact was preferable to prior restraint. The Pentagon Papers case is one that we discussed in class as well, and it's one where Daniel Ellsberg, they tried to prohibit him from publishing certain documents related to the Vietnam War, and the court held that any system of prior restraint bears a heavy presumption against its constitutionality. In other words, the court's going to look constitutionally and say prior restraint is not a good thing, that we'd rather go ahead and let them publish and do it afterwards, punish them afterwards for something if they violated somebody's rights or whatever. We talked in class, and we looked at as one of our examples, we looked at the Tinker versus Des Moines case, where the students wore black armbands in protest of the war in Vietnam, and that was determined to be protected speech. Again, you know my posture. My posture is err on the side of letting people express themselves freely, because that's in keeping with the Constitution. But again, there are obviously some restrictions. We talked about the case of bong hits for Jesus, or those types of things. There's also the Hazelwood versus Kohlmeyer case, where schools can exercise some control, like we talked about in bong hits for Jesus. And they have control over activities that have approval from the school. For example, the school newspaper. Obviously, we're very concerned about censorship, but it's a school organ. It's a school mouthpiece or whatever, and they have the right to control that to a certain extent. Board of Education versus PICO, that talked about the First Amendment rights of students were impacted by the removal of books from the school library. And we just touched on this. School officials do have a limited right of book removal. But again, I'm going to repeat, obscenity is not protected speech under either the First or the 14th Amendment. And I emphasize the 14th Amendment as being one that's really important. In Stanley versus Georgia, if the obscene material was in the possession of a person in their home, the Supreme Court held that the state cannot tell someone sitting alone in their house what they may read or view. But again, with pornography, especially child pornography, you've got a situation where there could be trafficking issues and those types of things. And there's ways that the prosecutor tries to get around the fact that there are, that the First Amendment exists and you should be able to view in your home what you want. But obviously, if you are exchanging pornography child pornography on the internet and those kinds of things, that's a problem. So, talking specifically about obscenity, we talked in class about the Miller versus California case, which is the key case in defining obscenity. And remember, we talked about Potter Stewart's basically saying, I don't know, I can't define obscenity, but I know it when I see it. Well, in Miller versus California, the court tried to define what was obscene. And you remember the standard. It's the average person applying to contemporary community standards, and they would find this work, whatever work they're reviewing, in light of these contemporary community standards, taken as a whole, appeals to the prurient interest. That's the first test, the prurient interest. And prurient is defined as having or encouraging an excessive interest in sexual matters. Other synonyms for the word prurient are salacious, licentious, voyeuristic, lascivious, lecherous, lustful, lewd, libidinous, lubricous, and formal. The formal is concupiscent. So, as an example, saying she was turned off by his prurient remarks. Obviously, something of a sexual nature. That's the first test, that it appeals to the prurient interest. The second test is whether the work depicts or describes in a patently offensive way sexual conduct, specifically as defined by an applicable state law. And again, the compelling state interest test also applies there as well, that we talked about earlier. And then the third test is whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So you take those three things and you apply them, and determine what's obscene. And so, for example, those standards would be given to a jury if they were being asked to determine if something was obscene. The court would relate those standards and then say, now, jury panel, you need to go into the jury room and you need to analyze this material in light of those three standards to determine if it's obscene. Nudity alone is not enough to make material legally obscene under the Miller standards. Just be aware of that. So just because there's naked pictures does not necessarily make it obscene. In FCC versus Pacifica Foundation, the Supreme Court, this is when they aired the filthy monologue words that we talked about earlier, and the Supreme Court looked to the time, place, and manner, which we talked about earlier, and it found that the warning by the radio station was not sufficient to protect minors. So, for example, they said before they aired it, this is going to be something that's going to be offensive, and you should turn it off or not let your kids listen to it, etc. So that's the time and place and manner. So if it's aired during the day when kids can hear it, even with a warning, it's probably not going to be good enough. Got to be very careful. In Reno versus ACLU, they challenged the constitutionality of the Communications Decency Act, which is one of the big hammers that the FCC tries to use. But the CDA does not look to time, place, or manner as to its restrictions. So even if you aired the filthy language, at 3 o'clock in the morning, when kids aren't likely to hear it, it doesn't matter. It's a content-based blanket restriction on speech on the internet and also on the airwaves. But it lacks the precision that the First Amendment requires, and so parts of the Communications Decency Act were struck down. A couple other ones. Again, coming back to child pornography, the prevention of sexual exploitation. This is New York versus Ferber. And abuse of children constitutes a government objective of surpassing importance. So while people may think they have the right to view child pornography in their homes or whatever, it's a very slippery slope, and obviously something that the state has a very strong interest in regulating. In Ashcroft versus Free Speech Coalition, the Child Pornography Prevention Act applies to virtual pornography, so pornography on the internet, etc. And it prohibits speech that records no crime and creates no victims by the material's production. And virtual pornography is not intrinsically related to the sexual exploitation of children. So just be aware of all these things. But obscenity is obviously something that can be regulated, and we know what the standard is now. We've looked at that. And so anytime you're trying to figure out, or if a jury's trying to figure out what's obscene, they're going to apply those standards. So that's obscenity in a nutshell. I encourage you to look at the slides that I put on the blackboard and view the other two videos about right to privacy and defamation, which are going to come up, and make sure you turn in the RFE by next week and participate in the forums. Let me know if you have any questions. Otherwise, have a great week. Thanks.